Hello and welcome to another video in our video series, 3 Minutes of California Family Law, brought to you by Family Law San Diego. I'm Bud Kluig, founding and managing attorney at Family Law San Diego. This video is about the difference between domestic violence restraining orders and civil harassment restraining orders. Now, they both are intended to stop or prevent physical violence, as well as threats of violence, as well as harassment. However, the main difference between domestic violence restraining orders and civil harassment is that to qualify to get a domestic violence restraining order, you have to have a specific relationship between the person asking for the restraining order, called the petitioner, and the other party, called the respondent, responding to the petition. The specific relationships are a spouse or a former spouse, people married to each other, cohabitant or former cohabitant, people who used to live together or are living together now, a dating or engaged relationship, the parties had a child together, or the male parent qualifies as a presumed father under the family code, or they are blood relatives, like parents or grandparents or siblings. If the relationship between the parties does not fall within one of those qualifying relationships and you are being harassed or threatened, you need to get a civil harassment restraining order. Civil harassment restraining orders are usually between neighbors or co-workers, and sometimes between the new significant others who have the same spouse or former spouse. It usually involves the person harassing each other or threatening each other. They're often involving property disputes, like property between neighbors. There needs to be some kind of violence or threats of violence. Now, the two types of restraining orders can be issued for different periods of time. For a domestic violence restraining order, the judge can issue a restraining order for up to 5 years. And down the line in a review hearing, the judge can issue a restraining order for life. For a civil harassment restraining order, the maximum time will be 3 years, not 5 years. And there's a difference in the standard of proof. What level do you have to prove your facts? For a civil harassment restraining order, it's called clear and convincing, and for the domestic violence restraining order, it's called preponderance of evidence. Now, without going into the weeds for this video, you can talk to an attorney about the difference between those two standards of proof and what you have to prove your case and get your restraining order. Now, please be clear that Family Law San Diego has handled both civil harassment restraining orders and domestic violence restraining orders many, many times over many, many years. So if you have any further questions about domestic violence restraining orders or civil harassment restraining orders or any other family law matter, please contact us at Family Law San Diego for a free consultation. And if you found this video to be helpful, please subscribe to our channel through the link below. You can contact us at Family Law San Diego by telephone at the number listed below, or visit our website, familylawsandiego.com. Thank you very much.